Hi, my name is Akiva Goldman. I'm the director of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. You know, in the context of divorce, we have statutory waiting periods. They are different whether or not they're children. So let's discuss what they are first and then the differences. The state of Michigan, in order to promote the continuation and the durability of the marital family unit, has set forth in the statute certain waiting periods that are required before a divorce will be granted. If you have a situation where you have a divorce with children, there's a 6-month waiting period. It doesn't mean that you have to wait 6 months before you can file. It doesn't mean that you can only file if you've been married for at least 6 months. It doesn't mean you can only file if you've been separated for 6 months. What it means is from the moment you file, even if you're only married for 1 day, the court is going to look at the marriage, look at the dynamic, and determine what waiting period is appropriate. If it's a situation where the court is going to have to make decisions regarding children, then the court sets up the lifespan of the case over a 6-month period. The life cycle of the case is going to go for that amount of time. That means about 5 months in, the court is going to start sending you notices that in a month you can finalize. So the court won't let you finalize shorter than that waiting period. There are exceptions. Sometimes if the case is at least 60 days old, the court might let you put proofs on the record. The court might let you finalize early if it makes a finding that's in the best interest of the children. Courts used to do this. They're getting away from that now. But the point is, the waiting period with children is, generally speaking, is going to be a 6-month period, which means if you start your divorce in January, don't expect it to finalize before sometime in July, because it's going to take the 6 months to go through the waiting period, even if everything's agreed upon. Now, with children, it's the 6 months, but without, a little bit different. Without, the court has less of an interest in seeing to the survival of the marriage, and therefore the 6-month period is reduced to 60 days, which means after 60 days, the court will invite you to finalize that divorce without children. Now, is it different whether the divorce is contested or uncontested? Generally not. In other words, if you have an uncontested divorce with no children, you're still waiting 60 days before that gets finalized. And if you have an uncontested divorce but there are children, it's going to take you every bit of that 180 days before that one gets finalized. Every now and then, everything will be resolved. It'll be, let's say, 130 days, and there's divorce with children, but the parties were, let's say, separated for years. So there's no particular compelling reason to wait out the extra days, because there's no way they're getting back together. They've already been living separately all this time. Maybe they don't even live in the same place. In that situation, the court might exercise discretion and say, okay, I see no particular reason to wait till day 181. Therefore, even though it's date 135, I'm going to grant the judgment of divorce. The court can do that. The court might also say, look, the court is loath to make the period run earlier. However, we will grant the divorce and take the proofs. We simply won't sign the final judgment of divorce until the waiting period passes. That's an option that's also available to the court. If you have any questions about your case, reach out, and we'll be glad to help you out.